Good morning. We'll call this meeting of the Committee on the Judiciary to order, and I'll ask the clerk to take the roll and ascertain the quorum is present.
Delegate Hanshaw, Delegate Capito, here. Delegate Queen, Delegate Zetezelo, Delegate Lovejoy, Delegate Lane, Delegate Canestraro, Delegate Holland, Delegate Savonia, Delegate Dean, Delegate Pushkin, Delegate Foster, Delegate Summers, Delegate Miller, Delegate Eisner, Delegate Moore, Delegate Kessinger, Delegate Robinson, Delegate Fast, Delegate Fluharty, Delegate Overington, Delegate Byrd, Delegate Harshbarger, Delegate Fleischauer, and Mr. Chairman.
Present. Quorum is present. And Delegate Byrd is arriving, so please mark him present as well. We're going to begin today with an affidavit that we received from Kim Ellis. She's a witness that has an attorney and is not able to be before us before the week of the 30th, and so we are going to provide this at this time for whatever weight you want to accord to it, and we'll ask counsel to explain how this affidavit was arrived at and to go ahead and read it, since it will be an exhibit for those of you with a notebook, but since this is an open hearing and we want those who are viewing our live stream to know what's going on with regard to this evidence, we'll read it into the record. Counsel, will you explain the process?
Yes, thank you. As the chairman indicated, Ms. Ellis is currently represented by counsel. We have been in contact with various witnesses throughout the course of these proceedings and have tried to work around scheduling. It is our understanding that this is one of those where scheduling would not permit the committee to be able to obtain any testimony until approximately the first week of August. So we went the route of the affidavit. Ms. Ellis provided testimony to the Judicial Investigation Commission, so that some of the information that was provided by her to the Judicial Investigation Commission was taken, and this affidavit was drafted as a result of that. It was provided to her counsel and then executed by Ms. Ellis. So that is the method by which the committee came into possession of this particular affidavit. As the chairman indicated, for purposes of those that may be listening, I will now read her affidavit into the record. The affidavit states as follows: I, Kimberly Ellis, being first duly sworn upon her oath, depose and say as follows. Number 1, my name is Kimberly Ellis, and I am over the age of 18. Number 2, I am currently employed with the Supreme Court of Appeals of West Virginia as the Director of Administrative Services in the administrative offices. Number 3, I began working for the Supreme Court of Appeals of West Virginia as Deputy Director of Administrative Services on May 16, 2013. I have held the position of Director of Administrative Services since November 1, 2015. My duties include, but are not limited to, managing the fleet vehicles, overseeing 2 warehouses, managing security systems, overseeing facilities, planning, and upkeep for the lower courts in all 55 counties, and consultation/facilitation regarding selection and procurement of furniture and equipment for the court. Number 6, construction on Justice Lawfrey's office began in June 2013. Number 7, my initial meeting with Justice Lawfrey to discuss the renovations to his office occurred before I was an employee of the court and while I was an employee of Silling Associates. The initial meeting occurred in Justice Lawfrey's current office. At that time, there was a desk in his office. The desk was an antique walnut desk specified by Cass Gilbert. Number 8, during my initial meeting with Justice Lawfrey to discuss the renovations to his office, there was a green leather couch in his office. That couch is now at the Venable Avenue warehouse. Number 9, during my initial meeting with Justice Lawfrey to discuss the renovations to his office, Justice Lawfrey did not mention to me that the desk in his office was a Cass Gilbert desk. Number 10, I left the employment of Silling Associates and began working for the Supreme Court of Appeals of West Virginia prior to the beginning of construction on Justice Lawfrey's office. Number 11, Justice Lawfrey was very involved in the decisions regarding the renovations to and furnishings of his office. Number 12, the construction costs associated with the renovations to Justice Lawfrey's office were discussed with Justice Lawfrey, and a detailed cost estimate was provided to Justice Lawfrey by the contractor before construction began. Number 13, the pillows for Justice Lawfrey's couch were ordered well after the renovations were completed. Justice Lawfrey decided that he wanted custom pillows, and he personally selected the fabrics and down inserts for the pillows. Number 14, Justice Lawfrey wanted a West Virginia map on the floor of his office. Justice Lawfrey hand-sketched the West Virginia map and the placement of his furnishings on a shell floor plan of his office, which also included his handwritten notes about other items he wanted for his office and their locations. Number 15, Justice Lawfrey wanted Tucker County to stand out on the map. He wanted the granite that was selected for his bathroom floor to be used for Tucker County. Number 16, Justice Lawfrey was updated throughout the project. I do not recall any surprises regarding the map. Number 17, I was asked by Justice Davis about a written or oral policy on allowing the justices to have a home office with furniture provided by the court, and I drafted a memo to Justice Davis in response to her request. Number 18, I was first made aware that a couch was at Justice Lawfrey's house when I received a call from Paul Mendez, a court employee who works for my division, informing me that he had been instructed to go to Justice Lawfrey's house and remove a green leather couch. During that phone call, Mr. Mendez also informed me that Justice Lawfrey had a Cass Gilbert desk at his house that he also wanted to remove, but they were only getting the couch at that time. Number 19, at the time of the phone call from Mr. Mendez referenced above, I did not know that a Cass-Gilbert desk or any other court furniture was located at Justice Lawfrey's residence. Number 20, other than Mr. Mendez, the only information that I had about the couch being returned to the warehouse was from information that I saw on social media. Number 21, it is my understanding that the couch was picked up on a Monday and the desk was supposed to be removed on the following day. However, Paul Mendez told me that Justice Lawfrey called off the removal of the desk for the following day and told Paul to be on standby because Justice Lawfrey wanted to wait until his neighbor left so that pictures wouldn't be taken and posted on social media again. Number 22, a few days after the couch and desk were both delivered to the warehouse, I went to the warehouse and observed and photographed the couch and the desk. Number 23, I received a phone call from Justice Lawfrey on the evening of January 4, 2017, which was the day that Steve Canterbury was fired. Justice Lawfrey called me at night on my personal cell phone and asked me to keep our conversation off the record. He informed me that he had fired Steve Canterbury. He also said that it was his understanding that I was a spy or loyal to Steve Canterbury, but I had nothing to worry about because they liked me. I felt like this was a threat and feared for my employment with the court. Number 24, it is my understanding that Justice Lawfrey also made a similar statement to my former assistant, Tamara Gilmore. Based on information and belief, while I was out of the office on court business, Justice Lawfrey instructed Tamara to come into his office and shut the door, and then told Tamara that he believed that she and I were spies for Steve Canterbury. Tamara found another job and resigned from her position with the court shortly thereafter. Number 25, on or about October 18, 2017, Sue Troy came to my office and requested my files on the renovations to Justice Lawfrey's office and Justice Davis's office. I provided her with my files on that date. Number 26. On the following day, October 19, 2017, I was contacted by Joan Mullins in the administrative office, and I was told that Judge Johnson wanted to see me in his office immediately. When I arrived at Judge Johnson's office, Justice Lawfrey was sitting at a table with administrative counsel sitting on both sides of him. Judge Johnson and Sue Troy were also present. Justice Lawfrey began questioning me about the costs associated with his office. Justice Lawfrey asked me if I recalled a meeting with him where I had written down on a piece of paper the cost for Justice Ketchum and Justice Workman's office, and I said that I did not. During this same meeting, Justice Lawfrey said that he had specifically told me over and over again that regardless of what is spent on his office, it was not to cost more than Justice Ketchum or Justice Workman's office. And he asked me if I recalled that conversation, and I said no. I felt like he was trying to intimidate me and coerce me to lie. Number 27, not long after the October 19, 2017 meeting in Judge Johnson's office, my personal office was relocated from an office suite located down the hall from the court's main administrative office to a smaller office located within the court's main administrative office between the offices of the court's two administrative counsel who were present at the October 19, 2017 meeting. Signed, Kimberly Ellis, and then notarized.
Thank you, counsel. And as indicated, that affidavit is now part of the exhibits as number 36. Counsel for Ms. Ellis has confirmed to us that Ms. Ellis will, if there's need to appear in the Senate for a trial, appear and testify consistent with that affidavit and authenticate any type of documents that are necessary. We're in the process of gathering various emails, extracting those from the JIC files, and we'll forward those to her for inspection and get her to authenticate them by affidavit before we conclude our proceedings. The next item that we're going to take up today, as I mentioned yesterday, in our conference with counsel for the JIC, it was pretty clear from their discussion of the hearing before the Finance Committee that they were taking into consideration the entirety of Justice Lawfrey's testimony as opposed to the excerpt that appeared in their charges. So we're going to play for you now the entirety of that testimony, at least insofar as it involved Justice Lawfrey. If we're ready, let's go ahead and play the tape. We need some volume.
Householder's mic.
I'll take a silent roll. Today's our first of quite a few budget hearings for the fiscal 19 budget, and we are starting off with the Supreme Court, and we'll have the Chief up here in just a little bit, and if we can hold the questions to the end, and then the Supremes will be followed by lottery at roughly 10 o'clock. So, Mr. Chief, and we do have a procedure that we do go through. So, will there be anybody else speaking?
No.
Okay. If you don't mind, the clerk will minister the oath. You're good. You're good. Just staying right here.
Oh, okay.
Yeah.
All right.
Yeah, here are my numbers. Please place your right hand over your heart.
Right hand over your heart, okay.
And state your name.
So, nothing like giving an oath to a justice.
Alan Lawfrey.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Thank you. Well, welcome. We're glad to have you here today, and the floor is all yours.
Thank you very much. It is my honor and privilege as Chief Justice of the Supreme Court of Appeals and administrative head of the third branch of government to speak with you today regarding the judiciary's budget for fiscal year 2019. I'd like to talk about that budget within the larger frame of reference that includes the judiciary's role in our government, recent concerns regarding Supreme Court expenditures, the successful efforts to cut millions of dollars from our budget last year, and the legislature's push for a constitutional amendment to diminish the judiciary's independence. We in the judiciary are painfully aware of the state's financial worries in recent years. This year will once again require difficult financial decisions from this legislative body, from the judicial branch, and from our governor. And in spite of recent headlines that may lead you to believe otherwise, the judicial branch of government takes this issue very seriously. In full consideration of these fiscal realities, I present to you the 2019 fiscal year budget in the amount of $139,759,670. This is approximately 1.1% of the entire state's budget. This budget represents a $2 million reduction from the amount requested by the Supreme Court last year and another $2 million from the year before that. And we make these reductions while our own workload has been increasing. Before we discuss specifics, I believe it is important to address the issue of some isolated excessive furniture expenditures at the Supreme Court and to place those expenditures in the overall project of which they were a part. The court has received significant negative press during the past couple of months regarding some isolated but obviously inappropriate purchases. Such extravagant expenditures damage the entire judiciary. People must have faith in our institutions to have civil order, and these expenditures are indefensible, and they are insensitive to all West Virginians. We live in a time of cynicism toward our government, and when stories such as this wasteful spending emerge, it feeds that cynicism and clouds the focus of the judiciary's mission to do justice. One action by any justice, judge, magistrate, administrative director, or any other employee within the judicial branch is instantaneously transmitted via social media around the world. When we act responsibly, humbly, and with regard for the people who come before us, we build trust. When we act in any other way, we damage the trust that people have in our judicial system. Shortly after this story broke, I received a letter from a citizen of our state. She wrote, in part, "After much thought about the story on TV, I thought each of you judges were supposed to be for the people of West Virginia. When you spend enormous amounts of taxpayers' hard-earned money, do you ever consider us as supplying your salary?" I called her and we discussed this issue. We found ourselves in complete agreement. There is simply no justification for such outrageous purchases. The important result of this conversation, however, is that I'm reminded every single day there is more work to be done to promote financial accountability and transparency in our government. Keeping this point firmly in mind, I do want to provide to you a clear view of the project within which these purchases were made. In 2008, the court began renovating offices on the 4th floor of the Capitol. It obtained bids for that project, and the original contract was for $876,156. The project covered 1/2 of the 4th floor. Given the disrepair of these offices, renovation was necessary for safety and provision of an appropriate workspace. The reporting of this project has been somewhat misleading. It has been widely reported that the court started with an $876,000 contract that ballooned out of control to $3.7 million. That leaves the impression that the $876,000 figure was the original overall estimate for all of the restoration and renovations that occurred on the 1st, 3rd, and 4th floors of the Capitol. That is inaccurate. The $876,156 contract was only to cover the cost of the renovation and restoration of the 4th floor counsel's office. Upon completion of that office, the justices who were on the court at that time began restoration wholly separate from the counsel's office, including renovating parts of the state's only public library, also on the 4th floor, and 3 offices on the 4th floor. Throughout the next few years, the project also continued on the 3rd floor, including the clerk's office, our courtroom, the hallway, the offices there, the public restrooms, our conference room, the hallway of the chambers, and the individual justices' offices. On the 1st floor, a conference room was also renovated. The scope of the work changed dramatically from the original contract. If you remove the isolated, unjustifiable furniture expenditures, you were left with renovations that were needed and necessary. The 1st, 3rd, and 4th floors of the east wing of the Capitol needed extensive electrical, heating, cooling, plumbing, and structural renovations. We have a responsibility to take care of this incredible building and the dedicated people who work in it. This is the context within which the court's foolish furniture expenditures needs to be viewed. Now let's talk in more detail about the judiciary's budget and our unified system of the courts. In 1974, the citizens of our state amended our Constitution to create a unified court system, and in so doing, greatly advanced judicial independence and effectiveness. Prior to these sweeping revisions to our Constitution, which were overwhelmingly approved by the voters in a subsequent election, the judiciary was fragmented, virtually unsupervised, and run primarily at the county level. As we move from that time period until today, I would ask that you think about the court differently and beyond the 5 justices in Charleston. Here in the Capitol, the judiciary's budget is frequently referred to as the Supreme Court's budget. We need to remember that our budget covers the operation of the courts in all 55 counties, not just in Charleston. Separate from the 5 justices, we have 279 judicial officers presiding over their own courts, including 74 circuit judges, 47 family court judges, and 158 magistrates. In addition to those judicial officers, the judiciary has many other people, functions, and responsibilities. We employ fewer than 1,500 people, with the largest group being more than 300 people statewide in our probation department. We also have magistrate assistants, circuit and family court judge secretaries, court reporters, and law clerks. Administrative staff, human resources, an IT department, educational training, accounting, and payroll, all serving the entire state of West Virginia. We have our Supreme Court Clerk's Office, our Chief Counsel's Office, Workers' Compensation Appeals, the State Law Library, the Board of Law Review, the Judicial Investigation Commission, the Lawyer Disciplinary Board, and much more. Given the nature of our work, our budget is necessarily employee-driven, but one of the most important points surrounding our budget is that approximately 90% of our spending is non-discretionary. The largest part of that 90% figure is for our 1,459 employees. And keep in mind, of those employees, the legislature, and not the court, actually sets the salaries for 663 of those individuals, totaling $50.6 million. For example, Supreme Court justices, circuit and family court judges, family court case coordinators, family court secretaries, magistrates, magistrate clerks, deputy magistrate clerks, and magistrate assistants are all set by the legislature. This fact means that separate from all of the other non-discretionary obligations contained within our budget, the legislature has significant control with regard to nearly half of our employees. And while the court system has certainly grown throughout the years, that is largely due to the unavoidable result of our socioeconomic challenges, and the most of that growth is a direct response to mandates passed by the legislature. The addition of drug courts and their increased budgetary demands is just one example. However, let's talk about where we are today and the direction that we're going in the future. When I was elected Chief Justice in January of 2017, I was well aware of the fiscal challenges facing West Virginia and made transparency and accountability of our budgetary process my primary mission. Since that time, our court has been going through more changes than any time in recent history, and these changes have created real savings. At the end of fiscal year 2016, we had a carryover balance of approximately $1.2 million. At the end of fiscal year 2017, we had approximately $8.5 million in carryover funds. These savings were not a response to any press coverage. They are simply the result of our commitment to sound financial management. Upon hiring new administrative leadership in Judge Gary Johnson in January of 2017, we began making seismic changes at rapid speeds. We began looking at everything, large and small. We started asking, what are the core functions that our court system must perform under the United States and West Virginia Constitution and under the laws of our state? When sitting down with our administrative team, I made it clear that everything must be on the table and nothing was untouchable. We had to evaluate what we were doing, and things not critical to our core mission as a court system must either be eliminated or substantially reduced. Even small amounts of money add up to large amounts of money. Change is not easy, but the court has begun building a more efficient and effective branch of government. Some of the financial changes that occurred in 2017 included reducing our spending by at least $7 million, eliminating non-essential positions, and with the help of the National Center for State Courts, beginning a significant reorganization. For example, reorganizing our probation division, saving millions of dollars, and setting up a system where sexual offenders will be more closely watched. Redesigning our professional services appointment and invoicing processes, saving hundreds of thousands of dollars. This includes our mental hygiene, guardian ad litem, and expert witness invoices. Moreover, our clarification of our rules regarding guardians ad litem in family court cases has enabled us to cut spending in that area by millions of dollars while still providing excellent service to our children. Changing the funding structure for drug courts to save hundreds of thousands of dollars while continuing to provide the level of services necessary to help these people change their lives. Putting procedures in place in our finance division that will change the transparency of the court forever. Even the simplest of actions with an invoice is now at least a two-person process. Reducing library staff and eliminating 7 underutilized regional law libraries at a savings of more than $200,000. Limiting the appointment of senior status judges when judicial officers are recused from cases. Instead, the Chief Justice appoints sitting judges from other circuits to travel and handle the particular cases, saving hundreds of thousands of dollars per year. Streamlining some of our educational programs and exploring ways to deliver more education to our people in more cost-effective ways, including web-based education. We have even made a change in the term of our Chief Justice. Instead of a 1-year rotation, the Chief Justice is now selected for a 4-year term with the ability to serve for subsequent terms. This change places more effective administrative and financial control in the hands of an elected official rather than an appointed employee. We have improved and implemented a procurement function with standards and processes in several of our divisions. We now research and utilize statewide contracts whenever possible. This change allowed us to immediately realize an approximately $100,000 savings upon reviewing our copier contracts throughout the state. We have broken down our internal budgeting into spending units, which creates more accountability. Monthly financial reports are now distributed to division directors to monitor spending, and P-cards and technology are to be used on an emergency basis and only with prior approval. And we're looking to the future in working toward the implementation of a statewide e-filing system that will save county commissions, litigants, and others significant amounts of money as we move into an essentially paperless process. We will also be able to provide accurate statistics to the legislative body that we are currently unable to provide. We have implemented significant cost savings in the Day Report Center program, wherein we realized more than $100,000 within the first quarter after making these changes. We received the largest federal drug court grant in the nation, $1.4 million. And we have expanded our legal division to allow more review, renegotiation, and oversight of all contracts and to implement policies, procedures, and standards that have been absent. This change has also allowed us to avoid large outside legal fees. These examples, and there are many more, should make it abundantly clear that this has been a year of significant financial improvement within the judicial branch of government. Our reorganization has created a more streamlined system and a management team of legal, education, probation, technology, court services, and finance that all work together to ensure that we are able to do our job in a more effective and efficient manner. These changes will shape the future of this branch in ways that will provide more accountability and transparency, but also meet the needs and challenges of the future. Having discussed these important structural and financial changes, I will tell you that we are not finished. However, I would now like to take just a few minutes to focus on some of the complexities of our budget and where it is difficult to significantly reduce spending. We have to have this conversation with the awareness of the non-negotiable elements of our judicial system. Article 3, Section 7 of our Constitution provides, "The courts of this state shall be open, and every person for an injury done to him in his person, property, or reputation shall have remedy by due course of law, and justice shall be administered without sale, denial, or delay." It is clear that without adequate funding of the judicial branch, we will not be able to provide or guarantee these constitutional rights. Moreover, it is also clear that administering justice is a constitutional mandate for all three branches of government. It is a core function. It is essential that we have adequate court funding. A few years ago, in his annual report, Chief Justice John Roberts said that failing to adequately fund the court system poses a genuine threat to public safety. He further explained that courts do not have discretionary programs they can postpone or eliminate because virtually all of their core functions are constitutionally or statutorily required. He explained that reductions in court spending cause widespread delays in civil cases, causing commercial uncertainty, lost opportunities, and unvindicated rights. Chief Justice Roberts made clear that failing to meet the judiciary's essential requirements undermines the public's confidence in all three branches of government. Without adequate funding of our judicial budget, West Virginians will experience a lack of services as problems will emerge from one end to the other. Delays in court services would happen, and justice delayed is tantamount to justice denied. Insufficient funding would cause specialty courts to be eliminated, and our troubled adults and juveniles would get much less supervision, if any at all. Insufficient funding would mean that significant costs would be added to West Virginia's general budget, and it would mean fewer opportunities for our citizens. While that may sound like a parade of horribles, it is a reality. Consider just a few examples of the constitutional and statutorily required work of the courts. Probation. West Virginia is one of just 13 states with the probation officers working out of the judicial branch of government. In the vast majority of states, probation is entirely an executive branch function. Probation costs amount to about 1/6 of our budget. Any cuts to probation officers means more jail time for non-violent offenders, costing the state of West Virginia and our individual counties millions of dollars to house these individuals in the regional jails and prisons. While that money is not coming out of the judicial budget, it nonetheless is a significant cost to the state of West Virginia. For example, if the current number of people in probation had to be incarcerated, it would cost the state of West Virginia more than $280 million for just 1 year. Those numbers are scary. Instead, the judicial branch spends a little more than $20 million to supervise and attempt to rehabilitate these individuals. Anyone can do that math. Along those same lines, our drug courts are helping to keep some individuals out of prison, helping them deal with their dependency issues, allowing them to find a job, take care of their families, and to become productive members of society. They walk away from these courts with a support system, and they are far more likely to succeed in life than an incarcerated felon. And again, consider the cost savings of millions of dollars not being used to incarcerate these individuals. We've had more than 1,600 drug court graduates since December of 2012 at a significant savings over incarceration. Indigent transcripts. We spend about $1.7 million per year to provide these transcripts, and those people have a constitutional right to them. That is non-discretionary. Language interpreters. It is necessary that we have an appropriate number of interpreters so that litigants, juries, judges, and others participating in court proceedings are able to understand what is being said in the courtroom. We spend more than $150,000 per year, and that is non-discretionary. Education. Educating our judicial officers and employees is critical to the services we provide. The 2017 year brought an influx of a significant number of new circuit judges, family court judges, and magistrates. To provide due process to our citizens, our judges must know the law and keep up with its changes, and so we in the court system have an obligation to educate them. Now let's briefly discuss the constitutional amendment issue. There is much talk at the moment about a constitutional amendment directed at the judiciary's budget. While this is discussed year after year, there is no doubt this will have more focus this year based upon the news regarding isolated but excessive furniture spending. When you discuss such an amendment, I would just ask that you take a moment and consider the big picture. Our constitutional structure is carefully thought out. The current constitutional provision says no item relating to the judiciary can be decreased. This provision prevents legislative interference with the judiciary and preserves the checks and balances by protecting against retribution by the legislature for any particular action that a court may take. And before you say, I would never punish the court for doing its job, let's look at what's been happening in the state of Kansas. The controversy began a few years ago when the executive and legislative branches became frustrated with some of their Supreme Court's decisions. Among those decisions was one dealing with school funding. In response to that Kansas Supreme Court decision, their legislature enacted a supplemental funding bill for the judiciary, but it included in it provisions that would have removed much of the Supreme Court's administrative power over its own courts. The provision was clearly unconstitutional. However, the bill contained a non-severability clause. It provided that the funding was void if the court struck down any section of the bill that removed the Supreme Court's power. This bill was a direct attempt to punish the Kansas Supreme Court for its decision. And the Kansas legislature passed the same thing the next year, except the provision said it removed all funding for the judicial branch. This is the sort of thing that can happen when court budgets are not independent. This didn't happen in 1816. This has been happening for the last few years. And similar controversies continue in those states where legislatures have significant budgetary authority over their court systems. It has often been said that a fair judiciary is the cornerstone of democracy. We must resolve disputes fairly, and we are often called upon to resolve deeply socially and politically divisive issues wherein the results may not be popular. We may be declaring a law written by this body to be unconstitutional. We simply must uphold the rights and protections of our constitutions. It has often been said that judicial financial independence is something that prior legislators and citizens of this state have worked hard to create and preserve. It was solidified in 1917 with the passage of a modern budget amendment, and it was further strengthened with the Judicial Reorganization Amendment of 1974. As Martin Luther King once wrote, "Injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly." I believe that those words ring true in considering the relationships between our three co-equal branches of government. The state constitution is a foundational document. Like a house, the state needs a stable and firm, not fluid and flexible, foundation. If we reject the foundational principle of a fiscally independent judiciary, we remove a portion of our state's foundation, making the whole less stable, less durable, and crucially, less safe for the most important principles of our democracy. We have unfortunately had many instances in all three branches of our government throughout our history that have led to the frustration and disappointment of our citizens. However, in none of those circumstances do I recall this body's response to be a constitutional amendment to reduce the authority of an entire branch of government. Instead, the proper and measured response was to institute policies and procedures that minimize the ability of individuals to act without transparency and accountability in the future. We in the judicial branch have done just these things. We have made significant staffing changes. We have implemented a reorganization replete with policies and procedures that will jealously guard our finances, and each of us will have to explain ourselves to the voters of West Virginia. And all I ask of you, our legislators, is that when you judge the acts of the isolated, wasteful spending that occurred years ago and those failures of oversight that allowed them, you do so in the judicious, measured fashion of any good judge. I ask that you take into account the extent to which we have ourselves remedied our own transgressions. While I certainly understand the legislature is concerned about instances of wasteful spending, I would rather each of the justices stand in front of the voters of this state and let them decide how we have managed the court's finances instead of having the drastic measure of a constitutional amendment that will significantly change this branch of government forever. In summary, this court is making significant changes with regard to how we do things, and these changes will benefit the court and the people of West Virginia for decades. We had a problem, and we addressed it. I am so proud to work in this branch of government and with these great judges, magistrates, and employees of the court system throughout this state. I would put these people up against any of their counterparts anywhere in this country, and I am saddened that these fine judicial officers and employees have been damaged from these recent stories. We will continue to work hard, and we will regain the trust of West Virginians. I am looking to the future as we are making substantial positive changes throughout the judicial branch. I sincerely thank you for your time today and for allowing me to talk about our judicial branch of government, recent changes, and our budget. Our three branches of government must continue to work together for the long-term interests of all of our citizens, and I can assure you that this branch will continue to operate with transparency, with integrity, and with impartiality. As Alexander Hamilton reflected, the ordinary administration of criminal and civil justice contributes more than any other circumstance to impressing upon the minds of people affection, esteem, and reverence toward their government. I thank you for your time today, and I look forward to answering your questions.
Thank you, Chief. Appreciate the information. I applaud your efforts and of yourself the last 2 years, and Justice Ketchum before you. And we'll open this up now for some questions. Vice Chairman Householder.
Thank you, Mr. Chairman, and thank you, Chief Justice Lawfrey. You know, there is no denying that there was wasteful spending and obviously extravagant purchases happening within the court. And I think that it begs the need for more transparency and oversight from this body. It appears that some safeguards have failed, and obviously there were renovation items that were not needed. And in the context of transparency, what is the court's plan to prevent the misappropriation of taxpayers' dollars in the future?
I think that's a wonderful question. And one of the things that we started in 2017 was we started a complete reorganization of the administrative office of the courts, and we brought in the National Center for State Courts. This was not a minor undertaking. I want to be very clear about this. We had a situation where an administrative director had 20-some people, I believe 27 people, reporting directly. It's irrelevant who the administrative directors are. I'm just talking about the structure, where you had 27 people reporting directly to that individual. So you had 27 silos. It makes no sense whatsoever. So you have 27 people out there making decisions. And what we did in working, again, with the National Center and looking at the structures of court systems throughout this entire country was we came up with something where you have the administrative director and you go down and you have 6 contacts that work with that individual. You have a legal division. You have finance. You have probation. You have technology. You have education, and you have court services. So now we have these individuals who meet weekly, number one, and we have communication, we have transparency. We've hired another wonderful thing that we did along those same lines. We hired 2 procurement individuals.
I was going to ask, so you don't think you have the fox guarding the hen house?
Absolutely not.
Okay.
So in the past, invoices would come in, invoices would get paid, invoices would go out. There's not a single invoice that comes in. My understanding is there's not a single invoice that comes into our court system where at least 2 individuals review those. And you know, I've been asked since this has occurred many times, well, don't the justices sign off on every invoice that comes through the court system? Well, no, and of course not, because we have more than 20, keep in mind, we're talking about an entire court system in all 55 counties. We have more than 25,000 invoices that come through the court system every single year. And on top of that, we have another 10 to 15,000 transactions on our purchasing cards. So, and we're also sitting down. We haven't had written procedures and protocols, and I want to have written procedures and protocols for everything. We need that. The people of West Virginia deserve that. So we want to put things in place so that not only this will never happen again, but it doesn't matter who is in the chief position or who's in the legislature or whatever. And another big thing that we did, and I know I touched upon it, but the change of the Chief Justice position is huge. It's not about me. I'm talking about 20 years down the road. Let's look at the renovation period, okay? These renovations occurred from 2008 until 2014, all right? I wasn't even on the court until 2013. So for that 6-year period, you had 5 individuals who served in a 1-year capacity as Chief Justice. I think that creates an impossibility. It puts a lot of pressure on each one of those individuals for any long-term project. I think that's one more example of how...
Well, you know, there is a lot of public pressure from this body to do something, because I don't think you would dispute that it was outrageous. There were a lot of claims. I mean, the average taxpayer, they're outraged from what was reported. So we want to make sure that there are some safeguards or assurances that this will not happen again.
I think that is an absolutely legitimate concern and question. There is nobody more outraged by these purchases than me. Many people in this room have known me for more than 2 decades, and they know that I would have never approved of such things. However, there was clearly a failure of oversight at the court. These things happened. We can't go back and change them, but what we can do is go forward and make sure that something like this never happens again.
Thank you. Thank you, Mr. Chairman.
Thank you. Yes, Dr. Coles.
Thank you, Mr. Chairman, and first, thank you, Mr. Chief Justice, for coming.
Thank you
To the meeting today, and I agree and appreciate with your comments that it is indefensible and insensitive and harmful to the court. But I appreciate you coming here to say that, and what I would, and I also appreciate the reorganization that you just talked about, because if we all recognize, and I think you recognized it before the media. But if we all recognize that changes need to be made, and you've made, it sounds like the court is making some reorganization changes. But the two things I would like to understand better is the timeline, the project origin, its completion, and you became the chief judge, or you got to the court in 2013?
That's correct.
The chief judge in 2017?
That's correct.
A new administrator in 2017?
That's correct.
And I guess the disgruntled employee started, it took that spot in 2017. You started 2017?
Well, I will say in 2017, I had the honor of the court hired Gary Johnson as a new administrative director, and he's doing a wonderful job in that position. In January, actually, my first day as chief, I guess.
So your reorganization has been fairly sizable. Changing administrator, changing processes and protocols and written procedures, and but if you could elaborate any on the timeline, that might help me as we go forward. And if you've already done some of these improved oversight issues from your perspective, what can we do short of a constitutional amendment, which I know bothers you? What do you think we, the legislature, could do? Because we have a role as well to protect the taxpayers.
You most certainly do have a role, and I understand that role, and I respect that role, and I think that our three co-equal branches of government have to have that respect for each other. So where to begin? So please interrupt me and stop me. You asked several questions, and I'll come back to the beginning. So you want more of a timeline for what occurred. So it is my understanding that in 2008, the court decided to begin some renovation and restoration on the 4th floor of the east wing of the Capitol. Okay? That is where our chief counsel's office is located. And there were 4 of the current members of the court were not even members of the court at that time. So the court decided to undertake that project. And from reviewing old notes, I saw that they did obtain a contract for that project. So they did that, and it was successful, and it improved that area drastically. And after that, the members of the court at that time began restoring these other areas of the court system. And from reviewing the notes, they did it in a way, it was done in a way that I wouldn't have done it, but nonetheless it was done that way. There was a utilization of 17 separate change orders that went forward. Moving forward, that's not how I would have proceeded on that, but nonetheless that's how it occurred. So the court then looked at renovating part of the library, which was also on the 4th floor. My understanding is none of this stuff had been done since the east wing of the Capitol had been completed in, I believe, December of 1928. And it has been reported to me that there were serious electrical issues, some structural issues, plumbing and heating, etc. So, and we do have a responsibility to take care of this building. The justices then moved into looking at the other areas. They saw the success of the chief counsel's office, so then restoration of our clerk's office occurred. Our clerk's office is busy. They do wonderful things. They process about 10,000 orders per year, and we put in a more safe workspace. created certainly a better work environment. Our courtroom. We have a magnificent courtroom. This is, I mean, Cass Gilbert designed this, and this was supposed to be his last job. And he took on one job after that, which was the U.S. Supreme Court, modeled on us. But nonetheless, we have a responsibility to take care of that courtroom.
I think the gentleman's also asking how we as a legislature can be involved with this process. Okay, so just to wind up the, and ask if I don't answer that fully, just to wind up the others. So then we went, then the court at that time completed the hallway renovations, offices, the conference room, the hallway of the justices, the conference room on the first floor. So it was a significant, it was a large project. One of the things that, answering the question a little more like this, is I believe that a big part of the responsibility has to come back on the court. When I come over here next year, I have to provide to you a more transparent budget than you've ever seen from the court system. And I think that you deserve that. I think you should be able to say, why do you want $139 million? You know, explain that to us. You know, you say that you spend you only get 1.1% of our total budget. So does that mean because you get so little, you're allowed to waste money? Absolutely not, and of course not. And I think this branch of government has to be transparent. And we have to be able to come to you and provide that information. And I think in just communications with the chairman, I'm not asking you to comment, but I believe that you've seen a transparency in the last year or so that is, you know, we're making these changes here.
Well, let me bounce one idea I have.
Yes.
Short of a constitutional amendment. What if the legislative branch or the executive branch controlled the space of the court? Any renovations we decided, any upgrades we decided, or the executive branch decided, whether that's the county commission at a courthouse or the Supreme Court's facilities here on campus. It strikes me that perhaps there's a bigger role for us to play in that rather than the court trying to do that themselves to their administrative needs.
You know, I think now I'm not speaking for the court because I'm standing here for me as I say this. I think that's a really legitimate question. When should we have three, perhaps this applies to the executive as well. Should we have individual branches who are able to take this wonderful building and do things without one, maybe it's a legislative joint body where we have to come in front of the legislature and say, we would like to do X, Y, and Z. I personally have no problem with that whatsoever.
Well, that's where my thoughts were going for some issue, and I don't have them formulated yet, but I just wanted to bounce it off.
Well, and let me throw this also out and just say that as far as a constitutional amendment, let's say that we had that in place. That would not have stopped these types of expenditures. I mean, what would have happened would have been there would have been a punishment the next year for that, but that's not going to stop something like that. I like your idea, and I'd like to explore that.
Thank you.
Much more. Thank you very much.
Thank you. Yes, Doug Boggs.
Thank you, Mr. Chairman. Mr. Chief Justice, thank you for being here. It's good to see you.
Good to see you.
I wanted to just go back a couple of things just for some perspective. Refresh my memory, how many other states oversee the judicial budget as the legislature controls the budget?
That's a really good question. And what will sound like a simple answer is this, because people say there's nowhere else in the country with a situation like this. And on the one hand, with the one aspect of it, that is correct. I'm not aware of another state where the legislature cannot reduce the court's budget. However, when you start talking about budgets throughout this state, there are as many ways of doing judicial budgets as there are states. And let me give you an example. Well, also think about it like this. In West Virginia, we have a unified system of courts. So our budget, again, covers all 55 counties, covers all of our court system. That's not the way it is across the country. I mean, you have hybrids all over the place. In many states, you have a Supreme Court budget, and you have separate budgets for whatever their court systems may be below, whether they're district courts or circuit courts, justices of the peace or magistrates. Some are set by the legislature, some are set at a county level. So it's not apples to apples when you look at these circumstances. And let's also look at the Supreme Court. Even though we have that idea of not being able to reduce the number, we've already talked about approximately 90% of our funding is non-discretionary. And when you start to look at some of the so-called discretionary money, really a lot of that is millions of dollars for a computer system and licensing for our uniform judicial application. And you wonder, is that really discretionary also? You know, this branch has the ultimate check and threat on the judicial branch of government because it's always looming to have that constitutional amendment. And what will probably happen is if this passes, you will see the judicial budget increase. Why is that? Because you're going to get pressured constantly because people are now going to come to you and they're going to say, we don't get enough money. The Supreme Court doesn't give us enough money for our family court rent. And over here in Braxton County, we need another probation officer. And over here, we need to do this and we need to do that. But I think we work very well together. If this court ever came in here, we've had a consistent budget. And if this court ever came in here, say for example next year, and said, we want, instead of 139 million, we want 180 million, and we're not going to tell you why. Well, that may happen for 1 year, but that constitutional amendment would pass rapidly. But that's never happened.
You mentioned the Kansas situation. Do you have any other examples of maybe the pendulum swinging too far the other way other than Kansas? Well,
so I go to these Chief Justice conference meetings, and you meet with Chief Justices from throughout the country. And you sit down and you have these conversations. It's very telling when you have judges and justices making comments that they're afraid to rule on a case a certain way because they're scared to death that the legislature is going to cut their budget. So a lot of these situations, they occur all the time. They just don't reach the newspapers in the same way that the Kansas situation did.
You mentioned something about the modern budget amendment. I thought you said 1917.
There was a 1917 amendment.
I was thinking of the modern budget amendment more in like 1960s.
Well,
70s.
Well, the 1917 budget amendment specifically provided this situation with regard to the judiciary's budget. The 1917.
Let me just alert the committee members. Apparently, our estimate of time of this testimony was we underestimated it a bit. But we've notified the court, so don't worry about our 10:30 appointment. We'll go when we're complete with this testimony, and the court is aware of it, and that's not going to create any problems. Go ahead and continue the tape.
And the others just dealt with the most recent just dealt with the executive branch versus the Board of Public Works putting together.
Well, and the 1917 amendment included other things as well, is my understanding.
There was just one final question, and this has nothing to do with it, but just out of curiosity. On the federal level, does Congress control the budget for the U.S. Supreme Court?
They do control the budget.
Okay. All right. Thank you.
And very good questions. And you heard some of the comments that I read from Chief Justice Roberts.
Thank you.
Thank you very much.
We have a couple more, and if I may ask, just we'll get to the summary answers.
I'll work on it.
Okay. Yes, Delegate Gerhardt, I'm sorry.
Thank you, Mr. Chairman. And my questions are quick and number-oriented. Number one, you indicated a $139 million budget.
That's correct.
The budget document says 141. What's the difference?
The difference is that we met in January and reviewed our finances, and we decided to drop that number, $2 million.
So where's the $2 million coming out of this? Mr. Chairman, I'm sure you know that there's $2 million.
We will follow up.
Yes.
Yes.
That will be gone. This document, my understanding is this document was not even available until yesterday, I believe. So
it's the budget bill.
That's correct.
That's it. There's $2 million more than $20. Second question. Each of your line items is set up as a reappropriated account. We're kind to mention how much carryover you had in 16 and 17. And between those 2 years, it was $9.7 million. I assume we're going to have an amount carryover for this year. My question is how much cash are you sitting on total in reappropriated accounts?
In reappropriated accounts, it's my understanding that it is $8.5 million. So,
okay, so what you're saying is that amounts you gave me were the total that you have accumulated, not just what each of those years turned back. Is that fair?
Well, I'm not sure I understand the question. So let me hear it again.
Okay.
What page are you on?
I'm looking at the budget bill, and each of your accounts, each of your line items is reappropriated. So your actual spend as compared to the budget, those dollars are coming back to you.
Oh, that's correct. So we have a.
This is how much total cash are you sitting on in reappropriated?
My understanding, because I don't want to say something that's incorrect. My understanding is $8.5 million.
Okay, I got you. Very good. Last question, and Delegate Walters came in late, and so I'm on his. I assumed he wasn't going to ask, but you have a couple of special revenue accounts. Account number 1757 and 1759, both of which have extremely light disbursements and very healthy influx and or balances. Between the two of them, about $1.6 million. Are we charging too much for the fees that are required here, or is there money that should be available to be captured by the legislature for reappropriation?
Let me see if I can locate those. Yes, I have something on special. So tell me which accounts one more time, Delegate.
1757 and 1759. And I apologize to Delegate Walters. I didn't think you were going to make it.
If anybody's looking at the, it's page 158.
Okay. In 1757, that is something called a parental education fund. And what this is for people going through divorce, and they could be ordered to take certain classes. The 1759 is called a parental education and mediation fund. Parents are ordered to mediation for child custody issues. I mean, these aren't things, these special revenue accounts are things created by the legislative body, as you're aware.
And I have appreciation for the function and purpose of the funds. My question, though, is that the amount of revenue in the funds and accumulating well exceeds the expenditures to accomplish the purpose of the funds, which means that those, we're either charging too much, frankly, for what folks are doing, or those dollars need to be put into play for expenditures as opposed to sitting in savings.
I have the 2017 current level numbers with me, and I do not have the 2018 current levels, but the numbers I had in there were much smaller, but I have 200,000 and 400,000. So you have 135,000.
No, it's 245.
245.
Okay, 245 and 1.4 million. Okay.
The 1.4.
If you can let him,
I'll answer.
come let him know, and then
Let me,
let the chief know.
Give
and then
me
he
1
can-
second.
That's based on.
Oh, that's a wonderful question. There was money placed in our account, not by us, by mistake, and I believe that money was regional jail money, 1.4 million. So this money was placed into our account by mistake. It was then put back into the proper account. So it was not money that went to the judiciary. There are other special accounts as well. We have an access to justice. It's something called access to justice account. It's a little misleading. I kind of wish you would rename that, because it's not really access to justice. That is something where all the money collected in the fees for the Supreme Court, that money goes directly to legal aid.
Doug Boggs, yes, what the yield?
Find out what the account was that went back into.
Yes, I will have our finance, my office will provide that information to you today.
That would be good, and I think it's questions like this that other agencies that come in, and the transparency and the discussion that goes on around not only special revenue line items but also general revenue line items, and so yes. Let me see. Sorry, Delegate Bates.
Just real quick, you mentioned the word transparency multiple times. Sometimes
Yes.
when something becomes very transparent, you can see right through it. So what I'm looking for is where would I, or a member of this legislature, or a member of the public, or a member of the press, find the detailed breakdown or analysis of your actual expenditures from 2017? Of the $134 million that was spent by the judiciary, where would an individual go to see where that money was spent? Where do I find that?
I think that's a good question. It's a fair question. And one thing, I'm not sure if they announced it yet or not, but the auditor is rolling out a new web page. I'm not certain if that has occurred today or not or whatever, but we've worked with them and asked them to feature us on the front page so that people can jump right into the Supreme Court and dig in and start to look at things. But some of our funding, when you look at our entire spending, so much of that spending is again employee driven.
So I'm sorry, I don't mean to interrupt, but we're on a timeline here. So where is the books? That's the question. Basically, if I had a $134 million business, I would have a set of books. So where are the books? Where do I go to find the books? Where do I go? Where does a member of this legislature, the press, or the public go to see the books of the Supreme Court, like the books of any other governmental agency? Where do I find those? Where do I see them?
Well,
Where do they exist?
what you have today is you have the information that has always been provided to this body, but I believe that the Supreme Court absolutely must provide more information.
Can you provide a commitment to this committee, the members of this committee and the legislature, that you will provide us with a copy of those expenditures from 2017?
That's fine with me.
So that we can consider your request. So I think we have that responsibility.
Okay.
Thank you.
Thank you.
Thank you, Mr. Chair.
Yes, Delegate Hartman.
Thank you, Mr. Chairman. Thank you.
We've just got a couple quick questions, if that's okay.
Okay.
For anybody else. Go ahead, I'm sorry.
Let's talk about the drug court's minutes. Does each circuit have a drug court? And is that mandated that they have one? That may be one of the most important expenditures that you can make today.
So this, I'll speak a little faster. So as you're well aware, this court mandated that drug courts occur. However, within that same legislation, it says the continuance or discontinuance is up to the court. However, we have drug courts, I believe in every circuit. I'm questioned one circuit because there was an issue with regard to day report centers, but there's nothing in our budget that is preventing. In fact, we just approved the start of another drug court this week. Won't mention where until we finalize our administrative minutes, but we're committed to this occurring. and people were able to change their lives. I mean, I've heard comments saying, well, we should get control of the budget because we want to put more money in the drug courts. But the thing about that is, there isn't anyone that I'm aware of who has not been able to participate in a drug court due to court funding. So they're providing a significant resource to the state, and we've been committed to those.
Thank you.
Thank you.
Doug Walters, we're going to do
it quick.
Okay.
I promise you. Within the Department of Administration, we're rewriting the purchasing division's function. My question is simply this, and it'll bounce off what Delegate Coles asked. You are exempt under purchasing currently. That bill is going to say that you will have the ability to work with the Department of Administration to establish rules and regulations. And then after a certain period of time, all agencies will come back under purchasing, but they will all have input. Are you okay with working with the Department of Administration to reformulate purchasing?
Part of it, so you said, but they will all have input. What do you mean? What do you mean by that?
Well, during the rulemaking process, and probably the chairman of rulemaking ought to answer this question, there's open hearings, there's comment periods. You have the ability to discuss the rules as they would apply to you, and then those rules have to come back to the legislature to be approved. And my question simply is this. If we rewrite the purchasing division, repackage it, and give you the opportunity to work in establishing the rules and regulations as it applies to you, will you be willing to be under purchasing?
You know, I think that's a good question, and I think that's a fair question. And I think if you tie that question with Delegate Cole's question, that also is another way where you're saying we can have more accountability and transparency of the judicial branch. I have not discussed that issue with the entire court. However, personally, it's not something that I would be opposed to.
Thank you.
Okay, so two last quick ones, please. I'm going way over on this one. Delegate Fritsch.
Oh, thank you, Mr. Chairman. Did you mention that a different way of funding day courts was part of your streamlining or savings? And was that due to the $1.4 million grant or something else?
No, it had nothing to do with the $1.4 million grant. What happened was, again, in starting to work with putting procedures and protocols in place, again, we looked at everything. I mean, we got into mental hygiene fees and guardian ad litem fees and our probation division and sexual offender probation officers. And we started looking at these day report centers, and we worked with them to come up with a per diem to provide the services that they needed to provide to us versus just invoicing back and forth without any accountability and ability to plan. So we did that, and we now have more transparency, but we're able to make those, we're able to plan better. So we're providing the same services, and we're doing so for less money.
Did you make drug court funding changes?
Well, that's what I was talking about.
So that was part of the day report.
With the drug courts, the court was spending, I believe last year or the year before, about $2.6 million just for drug tests. And there's no way of knowing when you do this how many people are going to be taking drug tests. I mean, there's a lot of unpredictability when you look at the court's budget. So we worked with them. We came up with a plan to where we pay them a per diem to provide these services. And within the very first quarter after doing this, we realized $100,000+ in savings. Now, in addition to that, with the various providers, we're having them work very hard to be able to get Medicaid reimbursement. And we think that will help us and also help them.
Right. And real quick, do you have any comments or updates on the real estate rent dispute in Montague County? I know it shouldn't make it local, but you've discussed it in the past.
No, I do not have any comments on that
thank
issue.
you.
Thank you, Delegate.
President Rose, last one.
Thank you very much for coming, sir. I agree. I share your concern about control of one branch by another. I think that's something we should all resist. But I do also appreciate your concerns about transparency, and I'm wondering from several questions. I hear from you that the court would be willing to look at the procedures that are used in other branches of state government and the reporting requirements, that the court would look at those and perhaps adopt those as its own in order to make sure that you have the transparency, that citizens can maybe go online and find out what their expenditures are and where they're going. And for my purposes, I'd be happy to know what category of spending there is as to the programs that you're supporting. But is that a fair statement that the court's looking at its procedures and reporting requirements to
there's no question about it. I mean, we're looking at everything, and as we continue, we're going to be able to get so far down into the weeds throughout this next year, and I think people deserve that. You know, I said to somebody, I said, I'm looking forward to going over and talking with finance, and they laughed and they said, no, you're not. I said, no, I really am. I really am. I'm proud of the work that we've done in the last year. Do I enjoy these stories and the things that have occurred? No. But I'm not going to stand before you and say that it's improper to ask these questions and for people to be outraged by such spending, because they should be outraged by it.
Thank you, Mr. Chairman.
Well, again, Chief Justice, we really appreciate your coming over and giving the report. I appreciate the moves that you and the court have made to become more efficient, but this body's...
I think that concludes Justice Lawford's testimony before Finance. A few comments about our visit to the Supreme Court. Those of you know that we requested that visit as a result of a request that was made at the conclusion of, I think, our meeting last week, our last meeting. The court has agreed. It was a request made on behalf of the members of our committee who wished to actually view the areas in the Supreme Court that were affected by the renovations. And we did some research to be sure that we're not overstepping our bounds and violating the open meetings law. And if you look at that section of the code under Section 6-9A2, there are a series of definitions. Number 5 defines the meeting that is subject to the Open Meetings Act, and there are some exceptions. The second exception reads as follows: any on-site inspection of any project or program. And because there have been a number of concerns raised by the renovations that occurred during the period that coincided with the reduction in the reserve fund in the court from $29 million plus or minus to less than $400,000 over about 4 or 5 years, I think it's relevant that we view those renovations, and that will be the scope of what we're doing. The court has asked us for efficiency that we divide into 2 groups instead of one large group, assuming that there's going to be more than 10 or 12 that want to go. This will not be a continuation of the meeting. It will be a separate tour that's been arranged for those of you who want to go. So if you don't want to go, you don't have to go. It won't matter. We'll divide just alphabetically. I think it'll be the simplest thing. Yes. What is your point of inquiry?
As to the, can I get mic'd? My mic? No. As to the procedure, you just mentioned section, I believe it's section 6-9A25B, which is the exception that is being cited by the Supreme Court. Now, that's being cited by them, not by our committee, correct? Are you justified?
No, we are relying on that exception. They haven't raised the issue. So
it is the ruling of the chair that we are inspecting a project or program. Could you just describe to me what the project or program is under that exception?
Yes, the renovations that occurred during the period of the reduction in the reserve fund of the court.
Well, I believe the project or program under that code is citing work product of an agency. I don't believe that renovations qualify as some sort of work product of an agency. And it's funny that you brought up the open meetings potential violation. As you know, any member who knowingly goes over, and now I heard that we're going to separate into 2 groups, which I believe is an attempt by the court to say that we're not going to meet the quorum requirement of an open meetings law violation. if we would do so, it would be a misdemeanor under the law. If you knowingly violate an open meetings law, that is a misdemeanor under the law, which could be brought against every member of this body.
Well, that's your interpretation of the act. We've conferred with other counsel, at least 3 lawyers, about the issue. They're all of the opinion unanimously that this provision would exempt this from a meeting. However, it's voluntary.
Who did you confer with?
Any member of the committee who does not want to go does not have to go. And so if you're concerned about that, I would suggest to you you don't go. And anyone else who's concerned about that.
Who did you confer with in reaching that understanding?
Well, we conferred with the chief of staff here, we conferred with our own counsel, and we conferred with the vice chair of our committee, who's also an attorney. So we have at least four attorneys that have reached the same opinion.
Did you discuss it with the Supreme Court? Because it's my understanding that the Supreme Court released a statement saying that these exceptions apply, not that the committee did.
I did not discuss it with the Supreme Court, and I did not see the release that you're referring to.
Is it your opinion that by going over and visiting the Supreme Court that it's not part of our deliberative process in these impeachment proceedings?
It's not part, no. There will be no decisions made, there will be no motions taken up, there won't be any testimony taken. It's just a simple viewing that's been requested by a member of your caucus, and that's what we.
But the information received by going over and visiting the Supreme Court would certainly play into the intellectual capacity of this committee to reach a decision. Notes can be taken. I don't believe you've restricted any video to this point. We can certainly receive that information.
Let me stop you there. They have said there won't be any photography other than what they're willing to work with our legislative photographer to take any photos that the committee wants.
So members of the body are not allowed to take photos
correct.
Of the furnishings and renovations paid for by taxpayers of West Virginia?
The decision of the Supreme Court is that they will take photos using our legislative photographer, but they will not allow individual photos taken by members.
So this is a decision by the Supreme Court, not a decision by this committee?
That's correct.
So we are allowing them to dictate our open meeting?
Once again, this is a voluntary visit arranged, just like anybody else could ask for a visit to the Supreme Court. We've asked as a group for members who wish to visit to be permitted to visit. It's a public building, but it's subject to certain controls, as we've had testimony that would indicate, for various reasons. And anyone here could make an individual request, if you wish, to visit that building. But we have made a request based on a request by a member of our committee that those who want to visit the Supreme Court and those areas of the Supreme Court affected by those projects will be permitted to do so this morning if we're finished with this discussion in time to do so.
Well, I'll wrap up here shortly. I understand time is of the essence, but it hasn't been for the past few days. Now, you mentioned this project or program. My reading and interpretation of this law is that it's an ongoing project or program. The renovations to the Supreme Court, that is a completed project or completed program, whatever definition you want to use. It is already done. I don't understand how we are violating this provision if those renovations have already been to completion.
And I do not read the word completed anywhere in that sentence. Do you see the word completed in there?
It is not. I think it's easily interpreted that way.
Well,
neither is project defined, neither is program defined, based upon my reading of the code.
If the legislature had wished to limit that to completed projects, it could have put the word completed in that sentence. It's not there.
Could have also defined project or program, which it did not.
It could have. It didn't.
Okay, so I would move, Mr. Chairman, we don't have, first off, let me ask, we don't have an actual ruling by any court saying that this is not an open meetings violation, correct?
That is correct.
We only have opinions by attorneys that you consulted.
Correct.
And we have an opinion by the Supreme Court that this exception applies.
I'll take your word for it. I haven't seen that opinion.
Okay. Well, I would move that we know we're going to be here next week. I would move that we delay visiting the Supreme Court because of the potential open meetings violation and the crimes that could be committed by doing so by members of this body. Or in the alternative, we choose, which we are allowed to do within our confines of the rules of the committee, that we take the media with us to the Supreme Court and put it on the Supreme Court to say that they're not allowed to be there and not have the decision be made by this committee.
And we'll entertain your motion. Is there a second to the gentleman's motion? There is a second. Is there discussion? Is there any discussion? Gentlelady from the 52nd? 51st, pardon me.
Thank you, Mr. Chairman. I think there's a balancing here. I think that most of us want to proceed quickly, but we already have a truncated day here. I don't think there's any harm of delaying and double checking. I'm not sure that it would, and this is something we could probably fit in. They only are having court 2 days a week. I personally am available Monday, Tuesday, and Wednesday next week, and wouldn't mind coming in on another day if it's consecutive, if we can work that out. I support the gentleman's motion. I don't see any reason not to be careful about this and make sure we're not trampling on the First Amendment and the rights of the press to accompany us.
Yes, Delegate Summers.
Chairman, did I misunderstand the motion? I thought the motion was not I thought he made that suggestion, but then he made a motion that we go upstairs with the press and have them deny their entry. Could he restate the motion?
The motion is somewhat contorted. The motion is either we delay or we go armed with the press.
I made it clear that my concern is that we can be committing an open meetings violation. So I believe the motion was pretty clear in that we should delay it. We're going to be here next week. We don't believe it's going to take a lot of time. We could come in at 8 a.m. if necessary if we want to start at 9 a.m. here, just because I would like to have clarification that we're not committing an open meetings violation. My motion was clear that we should delay it first, or in the alternative, bring the media with us, as I believe we have the discretion to do so. So if the media is with us, it's clearly not an open meetings violation. So then we're bypassing the possibility that it is. If we don't have the media with us and we go over there and there's a quorum present, which there would be even if we go in two separate groups, then I believe it could be an open meetings violation. So obviously step one, delay until we have clarification or an agreement is reached to bring the media. And step two, if that delay does not take place, in the alternative, take the media with us.
So two motions?
Well, you could separate them out if you'd like, but it was just a delay or in the alternative, take the motion with us.
Okay.
But we could separate them out if you'd like.
So just to clarify, the delay is to establish in what form whether or not we're violating.
I'll make a motion to delay.
All right.
And then if that fails,
what are you asking us to do if that I don't have a problem with that, but if that motion passes, what are you asking us to do that would avoid the same conversation coming up again next week if our request is granted and we schedule a second or another tour?
Well, I believe, Mr. Chairman, that the media would be able to play a role in trying to reach an agreement with the Supreme Court and this committee in saying that, okay, select individuals may be able to participate. And I believe we have the power as a committee. We're allowed to say, okay, media, you sit in the back row, you sit here in the committee process. We're allowed to dictate that. This is part of the committee process. This is a deliberative process in trying to reach an agreement. We're allowed to dictate the media as well in the confines of that subject material. In other words, we could say certain media members are allowed to accompany us to the Supreme Court. That's my understanding of the law.
Okay. I think I understand your point. Delegate, yes. Whose name is escaping me at the moment. Robinson, Delegate Robinson. Should never forget that one. Go ahead.
How could you Mr. Chairman, could you just clarify the section that you're speaking of about projects and what are we able to look at without it being a
yes,
committee meeting?
The code section is section 6-9A-2, the definitional section, subsection 5 that defines the word meeting. And the exception that we believe would apply would be subsection B, any on-site inspection of any project or program.
Mr. Chairman, is this tour or visit as the result of my request last Friday?
It is.
Mr. Chairman, I believe my request was to go look for framing and certain items that were hung or not hung or removed that weren't a part of renovation. It was just to look for items. So I don't know if we're actually looking at a project. It's actually just we're looking for a property that may have been converted to personal property.
My understanding of your request was that the office in which this alleged photos or framing exists is one of those that were affected by the renovations. And Your request was the trigger for this, but there were other individuals who, when you made your request, indicated other areas they'd like to see. So we asked for more exposure than just to the pictures.
Okay, Mr. Chairman, I'd also ask for the yeas and nays, please.
Okay, and we have, yes, Delegate Foster.
On the motion's just to delay the meeting, correct?
That's correct.
And on this delay, I would also ask that if we do delay, if this motion is successful, that we explore the fact of whether the press should be allowed or not. I think that is something that's a very important question, given that it is basically public dollars that has been expended.
It's my understanding that the press did make a request, but it hasn't been acted on yet. So perhaps a delay will give the court time to deal with that. So it may not be a bad idea. And in view of the hour, it may be less convenient for us to go now than it was before. So whatever the committee wishes to do, I'm not going to take a strong position one way or the other.
Right.
This was basically an accommodation. Delegate Moore.
Thank you, Mr. Chairman. I'd certainly support the gentleman's motion, particularly in regards to what you just touched on. I think that we want to accommodate certainly the members of the press, given how important this issue is that we're looking at, and let's not rush this and get into a situation where the First Amendment is not being fully recognized here, and so I think what's probably prudent is to, as the gentleman's motion on the table right now, is to delay and ensure that the media does have some level of access and giving us more time to do so. I think this perhaps might be a little rushed at this point. Thank you.
Further discussion? Delegate Lane.
Well, I'm going to vote no on the motion. I'm a little annoyed that we are having a delay motion from members of our committee who have been trying to get this done before August the 14th and has been complaining about all efforts to delay and stall. And I think that we have heard our chairman say that it is not a violation of the open meetings law. I've been looking forward to this site visit for a couple days, and I think that today is a good day to do it, and we can go ahead and get this over with. Thank you.
Further discussion? Delegate Fleischauer, followed by Delegate Fast, and then Delegate Overington.
Thank you, Mr. Chairman. I do agree with the lady from Kanawha that it is, we have been asking to proceed, but I think there are a couple things that militate against this one decision. One is it's going to subject the legislature to a lawsuit. There will be the media will file a lawsuit, and I don't think this is worthy of a lawsuit and worthy of the time of our staff. I also think that this is analogous to inspection that is done during a trial when they go see the scene of the crime. And this is like a trial. We are trying impeachment, so I think that we have been open to the media and that we should continue to do that. So because we're not certain, we're on uncharted territory here, I think we should just be careful. Oh, and the third reason is I think it's kind of strange that we would allow our legislative photographer, but we wouldn't allow the media in. And also that we wouldn't allow the members to take pictures. So I support the gentleman's motion. I realize there are arguments both ways, but I think it makes sense to delay.
Delegate Capito, followed by Delegate Fast and Delegate Overington.
Thank you, Mr. Chairman. I too support the gentleman's motion and would encourage other members of the committee to do so. We are here looking in the context of what we're doing here. We're talking about transparency, which is tremendously important in restoring the confidence that the citizens of West Virginia not only have in the judicial body, but the the government of the state, which we are a part of. So, again, I'll support the gentleman's motion and would encourage the body to do the same.
Delegate Fast.
Thank you, Mr. Chairman. Given that this meeting has been scheduled now for quite some time, I do have a question. Are there any prohibitions for members of the media or members of the public, for all that matters, to contact the Supreme Court at any time and request a tour of the facility? Or does the Supreme Court have a standing rule that those persons are not allowed in ever?
I'll answer to the best of my understanding. I think any member of the public could request the opportunity, but I think subject to security issues as well as confidentiality issues regarding the matters that are before the court, I think the court would have the discretion to control the number of people and the degree of access. But I think that I'm not aware of any prohibition against someone requesting it and being allowed to access subject to reasonable limitations. That's my understanding. I don't know if I haven't researched that issue. I will say this to the committee. It certainly wasn't our intention to expose any member of the committee to any potential misdemeanor offenses. It is our opinion we could do this subject to that, based on that exception. But if there is significant concern, I personally have no problem with the delay trying to resolve those issues, and certainly have no problem with the press resolving its issue with the court in the time frame that would be allowed between now and next week. So we were trying to expedite it. We had some time left on our schedule today, but I don't think it's a matter that's worthy of splitting the committee. We've managed to work really well together so far. So however you wish to vote on this, just vote the way your conscience directs you. Delegate Overington.
Thank you, Mr. Chairman. First of all, if this is delayed, I would request that we not have a separate meeting Monday, Tuesday, or Wednesday apart from our regularly scheduled meetings, just because some of us have 5-hour drive, 10 hours in round trips, whether it's a 5 or 4 or 3-hour drive or some other time frame. Do we know if the media is included, there would be additional restrictions on where we could go? I would think that would be a consideration. It's nice if the media could attend, but I would also wonder whether the media could make its own separate request and apart from ours. And I would be a little concerned that if the media is present, it's a great feature, but at the same time, the court may put additional restrictions on where we could go, which means we may not be able to get the full scope of the renovations and the changes that were made at the Supreme Court. Thank you, Mr. Chairman.
I understand your concern. I can't speak for the court, so I don't know whether there'd be any additional restrictions or not. But that's something that could be worked out with the media and the court personnel. Any other discussion? Delegate Miller?
Thank you, Mr. Chairman. I would support the gentleman's amendment. I find it ironic, well, before I get to that, in light of not being an attorney and the concerns of potential open meeting violations, I would advocate that we proceed with caution on this. Rather than make a mistake, we need to be sure of what we're doing. But as far as having access, and I'm not necessarily advocating for the media itself, or I don't think this is an argument just to allow the media to come with us, but I find it ironic that back during some of the visits that we have made in the off session in consideration of potential legislation dealing with our correction system that ultimately passed, that members of the media were actually allowed to go with us into our state's maximum security prison and be on the front line with us. They didn't take cameras or anything like that, but they were able to go see for themselves. They were able to accompany us into the maximum security prison, but they're not able to go along into the public's domain, a public-owned facility here in the capital of the state of West Virginia. So I find that ironic, but I would support the gentleman's motion. Thank you.
Further discussion? Delegate Pushkin.
Thank you, Mr. Chairman. Well, I
agree with the sentiments from the gentlelady from the 35th, who said that she's been waiting to go on this little excursion for a while. Well, so have all of us. And I've also been saying that we need to speed up these proceedings. They have been moving quite slowly so far. However, do I believe that we're going to uncover any new and enlightening evidence from taking a walk through that has been arranged by the Supreme Court? I find that highly unlikely, especially since the gentleman from the 36 made this request on Friday because he was specifically interested in knowing if some items that were framed, pictures that were framed and paid for by the citizens and the taxpayers of West Virginia, if they were still in the building. Since then, there has been ample time to either remove those items or put them back in the office that we wanted to look at. So while I feel that yes, time is of the essence, and I've wanted to get these proceedings moving more quickly, I think what's more important is the First Amendment of the United States, the Constitution of the United States of America. And I'm less concerned about the open meetings part as I am that I personally will not go over there without the media. This building belongs to the people of West Virginia. Those offices do not belong to the justices. They belong to the people of West Virginia. When those justices leave, somebody else will take that office. So the people deserve to see that ornate floor. They deserve to see the couch, and the media has a right to be there. So I'll support the motion, and hopefully we can work something out that will allow the freedom of the press to enter the building owned by the people of West Virginia.
Further, further discussion? Further discussion? The yeas and the nays have been demanded. Is the demand sustained? The demand is sustained. The clerk will call the roll. If you're in favor of the gentleman's motion, you'll say aye or yay. If you're opposed, no or nay. Please call the roll.
Delegate Hanshaw. Delegate Capito.
Yes.
Delegate Queen. Yes. Delegate Zetezelo. Yes. Delegate Lovejoy. Delegate Lane. Yes. Delegate Canestraro. Yes. Delegate Holland. Yes. Delegate Sabonia. Delegate Dean. Delegate Pushkin. Yes. Delegate Foster. Yes. Delegate Summers. Yes. Delegate Miller. Yes. Delegate Eisner. Yes. Delegate Moore. Yes. Delegate Kessinger. Delegate Robinson. Yes. Delegate Fast. Delegate Fluharty. Yes. Delegate Overington. Yes. Delegate Byrd. Yes. Delegate Hirschberger. Yes. Delegate Fleischauer.
Yes.
Mr. Chairman.
Yes. Are there any further motions to be made? All right, well, let's talk about how we're going to coordinate this so we don't go through this again next week. We will reissue our committee's request for sometime next week, understanding that we have a witness set Thursday by concurrence of his counsel, that's Mr. Canterbury, who will likely consume the whole day. So we'll probably be looking at Friday, whenever we can work this out, excuse me, with the court. Now, I don't know who speaks for the press, if they speak with a single voice. We certainly will cooperate, but I think that request is going to have to be made either individually or by some representative of the request to accompany well, let me back up a minute. Is it the sentiment of this group that we couple our request and condition it upon allowing the accompaniment of some members of the press? And I don't think that could be unlimited. I think we have to have some understanding here as to whether it's going to be 25 more people or it's going to be a handful. Since it was the gentleman from the third, I'm groping for whether it was the third or the fourth, the third who made the request, what is your suggestion as to how we do that?
Sorry, would you repeat the question, Mr. Chairman? How we should move forward?
The question is whether we ought to condition our request upon being accompanied by the press, and if so, is that unlimited, or is there some limitation on the group of the press that comes along? Because we could have 40 people that say they
brush off my old J school days, but My understanding is, and I think we're going to have an agreement from the back row, is that they could probably reach an agreement on who could be a representative of the media. I don't believe that, I think we have the discretion as a committee with that limitation as to how many and how they would proceed forward. Just like we do where how they would sit in our committee meetings. We're allowed to say sit in the back row, we're allowed to say X amount of individuals are allowed in.
All right, let me stop you a minute. I've been informed that the request of the media was for a pool of one broadcaster and one journalist. And I'll just look for nods of the head. Yes, okay. So if the gentleman would like to make the motion that we condition our visit on a pool of the broadcast media of one person from print media and one person from
so moved, Mr. Chairman.
Telecommunications media. I hope that's the right way to phrase it.
So
broadcast media, let me say that.
That means video, I assume?
Yes. Is that the gentleman's motion now?
Yes, Mr. Chairman.
All right, thank you. Is there a second to that motion? There's a second and a second to the second. All right. Is there discussion regarding the gentleman's motion? Yes. Delegate Queen.
So are we allowing 2 members of the media to go with us?
I think that...
Well, I believe there's one broadcast and one print. Was that how we clarified it?
All right.
Radio, TV, and print.
It's your motion. Why don't you take a minute and clarify?
Radio, TV, and print. So 3 total. 1 from each.
Any cameras?
I believe, yes. Well, broadcast media would...
Are we asking for 1 video and 1 still? That's usually how a court...
You're the trained photographer, so now you're getting into an area.
Well, that's what I think usually in a court proceeding they do allow 1 video camera, 1 still camera, and the willingness and the mandatory action to share within the other media outlets.
If my motion was not clear on that, I would so amend the motion to be reflective of your changes.
And I'll ask one more general question to the fact, will you allow... Never mind, I'll stay quiet. All right, thanks.
All right, do we have clarity on the motion now?
I believe so. We have 1 media, 1 print, 1 still photography. Correct? Is that how you wanted it? Radio.
Gentlemen, just Delegate Queen, you yield for that question?
The cameras, I think, are going to be the issue. If you do one still, 1 video, and then that 3rd member of the media will just be able to walk, take notes, and then write a story later.
I mean, I don't have a problem with that. I think that covers all the bases. That's 3 different areas.
I support
that.
Okay, so that clarifies the motion. And let me restate the gentleman's motion to make sure I understand it. The motion is that we request next Friday a tour of the facility as a committee accompanied by 3 members of the press, 1 broadcast, 1 print, 1 still photographer. Is that it? Radio in addition to broadcast. Is that covered? Just a moment. I want to be sure we got the motion right.
We're going to have 3. Yeah, I mean, their ability to what they do within, I mean, we don't want 3 with a bunch of I suppose the goal of the chair here is to make it clear to the court that we're not going to bombard them with a bunch of equipment. So if we limit it to 1 broadcast, that's 1 person going in with the video. We limit it to, I guess, 1 photographer, which the delegate brought up, and then 1 print media, which I assume could include radio. They could record things. I suppose they absolutely have the ability to record what's being said in there. So I think we've covered it.
I'm not in the debate stage. I just want to be sure I understand your motion. Okay. The motion has been made, and is the second accepting the clarified motion? Okay. Now, Delegate Robinson followed by Delegate Pushkin for discussion, and Delegate Zatazalo.
Mr. Chairman, being as we're 50 yards away, could we amend that to say earliest possible? I mean, we're 50 yards away. I'm sure they're watching. If they could say they're okay with that, we could go there immediately like we planned. I mean, we're putting it off a week, but if they would just...
think we've already voted to delay the tour. Delegate Pushkin.
Thank you, Mr. Chairman. Would the gentleman from the 3rd be willing to amend his motion to state there would be one broadcast, one TV, one member of the media from the radio, and then that the print media also be able to take still pictures? It's not included. The radio wasn't included. This would include radio, but to keep it to 3 people, while the print media would be able to take the still pictures.
We're keeping it to 3 people. Still,
yeah, it's
right?
3 people. Well, I'm including radio.
They can decide who are we allowing to decide the 3? I assume we let them decide it and move on. So sure, I mean, we can include radio in that, just as long as they're not coming in with a bunch of cameras.
No, it's be one still. What I was getting at is one still photographer would also be the representative of print media.
Okay. No, I think that was already covered. How was that not covered? It's not covered.
To the gentleman from the 3rd, does that modify your amendment, or you just want to let the press decide among themselves who the 3 representatives would be?
Yeah. Let's let the press decide on that.
All right. So the motion now is
we're limited to 3. Let the press decide. One broadcast. I feel like print is an umbrella. It could include radio.
Let's just let the press decide which 3.
Perfect.
All right. Delegate Zatazalo.
Thank you, Mr. Chairman. I just have one question for the committee. Is there some way to guarantee that the criteria for open meetings is met by the media? Does the media have a plan for distribution, to make sure that everybody who might want to see gets the information that they're going to collect?
Well, if I understand your question, we would not be going as an effort to be an exception to the Open Meetings Act. This would be a continuation of a meeting. We would have a quorum present. It would be open to representatives of the public in the form of the media, but I don't think that it's going to create a problem. But we'll certainly seek further opinions on that as to whether it has to be totally open to the public, in which case that could create a problem. And we may have to figure out a way to fit within the scope of the rule, the exception, and that's probably doable. We can do that. I think we can figure that out. But we'll focus on that in the time period between now and then. And we have a motion and a second. Excuse me. In a second, is there further discussion? Delegate Overington, followed by Delegate Holland.
Thank you, Mr. Chair. To the chair, you had explained that in arranging the meeting that had been planned for today, that we would have to be broken up into 2 or more groups to accommodate the touring.
Well, just from a logistical standpoint, the more people we have crowded into a particular person's office, it may be difficult for those who want us to look to even see anything. So I suspect the court will ask us, just for the logistical purposes, to somehow break down into a manageable units that would allow, a meaningful tour. That would be my impression. That would be sort of up to them. But as long as we're all there and relatively close together, I think we would still be considered part of the meeting. Now, how the press divides up their representatives would be up to them if we're divided into groups. That's my opinion, but I think the court will be making that call as to how they want to take us through the facility.
Thank you.
Delegate Holland.
Thank you, Mr. Chairman. This is a point of clarification. If the court does not get back with us on this request, then the group tour is no longer on at that point?
Well, it's no longer on at the moment, and we'll see how the court responds to our request. If they have an alternative suggestion, we'll certainly bring that up to our members, but I think we ought to assume that it's a reasonable request and they'll figure out some way to grant it. they've been relatively cooperative so far. I think they would work with us.
Great. Thank you.
Further discussion? And the question for the committee is the gentleman's motion. All in favor will say aye. Aye. Opposed, no. The ayes appear to have it. The ayes do have it. The motion is granted.
Just add housekeeping parking lot for next week, and you can enter under the front side.
One housekeeping issue before we recess. We've been informed, if you received the memo, the email memo from the clerk, you know that the normal entrance down here on this end of the building is under renovation. So the clerk has arranged parking next week on the front boulevard, on Canal Boulevard, and you can probably enter through the lower entrance on the ground floor. I assume that won't affect the east wing. You could still come through the east wing or through the security other. But the entrance that many of us that park on California Avenue out here is going to be under construction, so you won't be able to come in that way. So the parking that's designated for us, which is usually by the blue bag over the meter, will all be along Canal Boulevard. Other questions? Delegate Flashour.
Thank you, Mr. Chairman. I like the suggestion of the delegate from Kanawha that we check with the court and see if they're available today. It is 20 minutes or till lunchtime. We've all come all the way down here. We have some really intense meetings next week. I'll go with the will of the committee, but it seemed to me that it would be worthwhile, since it's right before lunch, to check with them and see if they would go along. They're, as someone said, probably listening to this. I think it would be good to get this done, but I'll go along with the will of the committee, and I'll make a motion to that effect unless there's a huge hue and cry.
Why don't we be at ease for a moment and just have a council call over there, and then we can rescind our delay motion, and if they're able to accommodate us, we can do so today.
Mr. Chairman, I don't think we said delay till a date certain. We are delaying at this point. We could delay until later this afternoon if they would go along with it.
I'll just have to check the terms of the motion.
I'd appreciate that, Mr. Chairman.
Pardon?
Oh.
I think it was, the clerk tells me it was a motion to delay until next week, so the proper motion would be to rescind that motion, but let's just check first.
Thank you, Mr. Chairman. I appreciate that.
Members, please stand at ease for a minute while we make the inquiry.
So, given the meeting thing of the week, then we recess, or do we just go over there?
I think we just go over there.
And we have to come back to recess?
Yes.
Okay.
Well, let's think about that. Let's think about that. Any difference is having the press with us. A limited number of people on the press with us going to get us around the exception that we talked about. Because the question is whether we continue our meeting over there or we recess.
Recess
because the association, Broadcasters Association, they have to get together. They don't have time to.
Yeah, but if we reset.
We've asked.
Oh, they said no?
They said they need to get the court back together to...
All right.
Please take your seats. To the members of the committee, we did communicate to the court. We were informed that because of the change in the nature of the so-called tour, that they needed to gather the court back together again to discuss it, and so it's not going to happen this afternoon. I also understand that maybe the media might need a little more time to get their representatives together. So we will communicate that request that was confirmed by the committee to the court for next Friday, and as soon as we get a response, we'll share it with everyone, and hopefully we'll be able to go forward at that time. And we'll just have to deal with the testimony to conform to the time that we're given by the court. There's some concern that Mr. Canterbury's testimony may take more than a day. Who knows? Certainly hope not, but that's a possibility. But we'll make sure that if they give us a time, we'll be there. Is there any further business to come before our meeting before we recess? Delegate Byrd, do you have a question or an inquiry?
Just an inquiry, Mr. Chairman. Given this possible tour next week in Canterbury, does the chair have any idea of like maybe a proposed schedule? I know we'll have to probably fluctuate given the response from the court, but any proposals?
I can tell you what we'll be looking at to try to work into the schedule. There's been a request by one of our managers for a subpoena for Justice Lawfrey's wife to testify about certain factual issues. We will issue that subpoena. There's been an inquiry about the so-called missing computer. We're going to try to find out who would be able to confirm or confirm one way or the other whether those facts are correct. We've got we gathered just this week some additional information regarding the renovation expenses. Staff will be organizing that, determining how we're going to present, what, if any, of that we're going to present and by whom. My understanding that the auditor's office has some information regarding the issue that was raised about the employment of Mr. Pritt as a consultant, and we'll be determining whether that information is going to be relevant and needs to be presented. Some of our managers are doing some additional work on the issue of the Tucker County Magistrate Court case and also the Greenbrier book signing trips with state vehicles. So all of those things, to the extent we develop documents or testimony or in some cases perhaps affidavits, will be blending into next week's schedule. So hopefully we'll have a full schedule and no holes in it. But it all depends on how that comes together. Yes, sir. Delegate Pushkin.
Thank you, Mr. Chairman. It's the point of inquiry. In light of the affidavit that we received at the beginning of the hearing today from Ms. Ellis, specifically points 11 through 16, that I would say validates some of the other evidence that has not yet been entered in. Specifically emails from Justice Lawfrey concerning some of the spending in his office, invoices that he had signed, and a sketch of his floor. I was going to ask if this affidavit validates those items, they could be entered in as evidence as well.
The plan was, and I think I introduced this, I mentioned this earlier, but maybe I wasn't very clear. We're going to ask Ms. Ellis to supplement her affidavit by verifying or authenticating copies of the sketch and the emails that she either authored or received, and we'll do that by a supplemental affidavit. We were in the process of trying to get the basic facts in an affidavit. There was some time constraints on doing that, but we will, and some of that evidence could probably be authenticated by Mr. Canterbury. I think he can identify the sketch. There'll be I'm sure there's some emails that he was copied on or authored that went to Miss Ellis, but we're going to try to get that information back in time to be submitted as exhibits, as a supplement to her affidavit. But in all likelihood, some of that can be authenticated by Mr. Canterbury.
Okay, thank you.
Delegate Overington, question.
Thank you, Mr. Chairman. Do you anticipate that we will be meeting Saturday and also the following week, Thursday and Friday, and for long-term planning sake?
First of all, I would plan on Saturday because it looks like if all this comes together, we could very well spill over into Saturday. But as we had plans to go into Saturday this week, and we had some issues with availability of witnesses and other issues that are abundantly clear at the moment. So I can't be sure about that. The following week, we have some real issues with staff vacations. So as soon as we determine whether we will be able to cover the following week with staff, I'll let everybody know. But at this point, that may be a problem, the week of the 30th. Delegate Fast.
Thank you. Ms. Ellis, I understand she submitted this affidavit, and I just want to clarify, was that in lieu of testimony or just to get us along right now until such time as she can come and appear before this committee?
At the moment, it's in lieu of testimony.
Okay. I would certainly like her to appear before this committee for questions. I think that's
we'll take
very
that up.
important.
I will say that both the JIC representatives and indirectly from the U.S. Attorney's Office, they've asked us not to bring her. So for what it's worth, but the committee can do whatever the committee wishes to do about that.
I'm specifically requesting a subpoena for her appearance.
All right.
Thank you.
We'll take that up with our managers. We're going to have, and that brings up, I'm glad you raised that. We'd like to meet with the managers shortly after we're recessed today so we can discuss the plans for next week and what still needs to be gathered. Delegate Flashhour.
Thank you, Mr. Chairman. I just wanted to clarify about that week of the 30th, of Thursday, Friday, and Saturday. Is that up in the air?
It is.
Okay, thanks.
Further questions? If not, Chair recognizes our acting Vice Chair, Delegate Capito.
Thank you, Mr. Chairman. I move that the committee stand in recess until 9 a.m. on July 26th, which is a Thursday, next Thursday.
You've heard the gentleman's motion. All in favor will say aye. Aye. Opposed, no. The ayes have it. We are in recess until Thursday, next Thursday at 9 a.m.
Because I'm glad they were on time.